Number E011 of 2025, Geoffrey, Dungo, and others. Other 4. Number E011 of 2025, Geoffrey, Dungo, and others. Other 4.
For the first accused person, as well as the third accused person.
For first and third accused?
Yes, yes, my lady.
May I plead the case?
Yes.
In the matter, my name is Bukto. Watching brief for the family on behalf of the Law Society of Kenya.
Who else? Who else? We are full house. Kenya National Commission on Human Rights. Mr. Gatti. Miss Gogi. So Ms. Gogi for second accused is absent. Can we still proceed nevertheless?
Yes, my lady, I can hold brief for Ms. Ngugi. Mùrdered.
What about for fifth accused? Who will hold brief for Mr. Gatti?
Yes.
Ms. Awol, you can hold brief for... Then we can even proceed without the Madam Wewa for Kenya National Commission on Human Rights. We can still proceed. Good. We'll proceed. Would you like me to read the whole thing? The whole ruling, or I go to determination? Wamaitha? Awol, can we go to the analysis and determination, or we read the whole thing?
It would be good if you read the whole thing.
All right.
Or read.
Let me do it. Let me do it. These people can sit, isn't it? It's not a trial. So let them sit somewhere. Move for them to sit at the front. So this is the ruling. Geoffrey Dungo Wili, herein referred to as the first accused. They are all represented. Do you understand a bit of English? You understand English? Ha, spare us that. Let me start. They understand. So Geoffrey Dungo Wili, herein referred to as the first accused, moved this court by a notice of motion dated 1st April 2025. It was brought under Article 10(2)(b), 25(c), 50, Sabbatical 2A and 5, and 51(1) and 159(2)(d) of the Constitution of Kenya. He was seeking the following orders. This honorable court be pleased to order the advocate watching brief for the family, Ms. Wamaitha Rosarida, Ms. Mothama Rosarida Wamaitha of number 105/7466/20, commonly practicing in the name of Ms. Wamaitha, be recused and or barred from participating in the proceedings herein. Counsel watching brief for the family be compelled by this court to confirm the firm for which she practices in, that herself, her agents, and or her agents be restrained from visiting the accused persons in prison where they are currently held at GK Prison Nakuru. The basis of this application is on the face of it and supported by the affidavit that was sworn by the first accused on 1st of April 2025 with authority of the second to fifth accused persons. It states that they were all charged with the offense of murder contrary to Section 203 as read with Section 204 of the Penal Code and are currently remanded at Nakuru Main Prison awaiting hearing of their board terms. It is his case that prior to the arrest, Ms. Wamaitha, herein referred to as respondent, advocate watching brief for the victim's family in this case, called the second accused requesting to meet him in Joro on 23rd of February 2025. The second accused agreed to meet her on 25th of February 2025, and they had a lengthy conversation pertaining to this case. She promised to help him, that is the second accused, with the case herein. Thereafter, she offered to buy him lunch. He states that based on their conversation, he shared with her very important information pertaining to this murder case. Hence, the two initiated an advocate-client relationship. He deposed that while the second accused was about to partake his lunch bought by the respondent, she, out of malice, called the police officers who arrested the second accused. He states that the respondent was with the second accused at DCI offices while he was recording his statement and that she promised to help him with the case. However, upon the second accused being arraigned in court, she declined to represent him and shifted to the other side to watch brief for the family. He maintains that the second accused gave the respondent a lot of crucial incriminating information concerning the case herein, and therefore her inclusion in the case would be detrimental and prejudicial to his case. He explains that while they were remanded, the respondent called them through the welfare office saying that she wanted to meet them the following day as she had crucial information to share with them, that when they asked her to go through the advocate, she replied that the information will not be shared with the advocate. He states that the respondent took advantage of her position as an advocate and visited the first to third accused persons on 12th of March 2025 and connivingly convinced them to plead guilty to the charge of murder, upon which they will be assisted by the MP commonly known as KK. In addition to agreeing to plead guilty, the respondent promised them a reward of 100,000 shillings each. He expounds that on 13th of February 2025, the respondent met with the fifth accused and asked him to plead guilty on the basis that he too would be assisted by the MP. His position is that despite their refusal to bow to the respondent's pressure to plead guilty, she persisted in her quest and even sent proxies to convince them while they were in remand. He states that the respondent's unrelenting spirit caused them to dig deep into the relationship between her and the deceased, and the deceased's lover, and a friend to the MP, thus her crowded judgment in the matter. He further states that the respondent has taken her practicing certificate under the firm of Kariuki Moigwa and Company Advocates, but upon inquiry, it has been confirmed by Mr. Moigwa Advocate that the respondent does not practice under his law firm. He explains that further investigations revealed that the firm of Wamaitha, Makori and Company Advocates, where the respondent claims to be working from, is not registered. On that note, he urges the court to allow the application as prayed and adds that application of cab rank rule is not absolute, especially in the instances such as these where there is apparent conflict of interest. The third accused also filed an affidavit sworn on the 8th of April 2025 supporting the application and reiterating the averments in the supporting affidavit of the first accused. He adds that the respondent has been mobilizing a mob to resist this application herein and hold the board hearing. Further, he states that a video of this was posted in TikTok account at mc.toto.mose. The respondent has opposed the application, and in her replying affidavit sworn on 7th of April 2025, she states that she is an advocate of the High Court of Kenya with a current practicing certificate. She says she prays for dismissal of this application with costs for being unmerited, bad in law, and an abuse of court process. It is her case that allegations against her are unsubstantiated and aimed at barring her from motion grief for the family of the deceased in this murder trial. Her position is that an advocate has the right to act for any client, and a client has the right to appoint whichever advocate he or she desires to represent him or her in any matter. She maintains that it is a constitutional right to be represented by counsel of choice, and that right should not be interfered with on allegations which are otherwise tinctured by malice. She therefore terms the effect of prayer sought herein as infringement on the family's right to representation. She elaborates that the right of representation may be limited in certain circumstances, either where there is a possibility of an advocate will be called as a witness, or there is a conflict of interest. Conversely, that there is no indication that she is likely to be called as a witness in this murder trial. In any event, that she has neither recorded any witness statement with the police, nor the prosecution given any indication that they intend to summon her during trial. She refutes the allegation of meeting the second accused and having lengthy talks regarding the instant matter, and even agreeing to represent him in court. Moreover, she states that no interior evidence is stated before this court in support of the allegations of existence of any advocate-client relationship between her and the accused. She maintains that the applicants must prove a proper basis to the court to enable it to make determination, and states that without establishing professional relationship between the advocate and the accused, no basis has been laid for the allegation of protecting purported confidential or privileged information that could be used in detrimental manner. She states that, for instance, she was not paid any professional fees. There was no evidence that she drew any documents on behalf of the accused persons. She questions the authority of the first accused to swear the affidavit on behalf of the other accused persons, and states that no such authority was stated, and besides, the accused persons are represented by different advocates. She further denies calling police to arrest the second accused person or visiting the prison to discuss the case herein, to coerce him to plead to the charge of against them. Further, she denies offering a bribe of 100,000 shillings to the accused persons to plead guilty to the charges. She is aggrieved by the tone used by the applicants herein, arguing that it is a confirmation that the applicants are just coming up with allegations in a bid to try and convince the court, yet this court is only convinced by evidence and not abstract. On the claim that she had an affair with the deceased, she states that such allegations are aimed at maligning and tainting her name, and is in fact insensitive to the family of the deceased, especially the wife. On the alleged non-existence of her farm, she annexes a copy of certificate of registration of her farm, Wamaitha Macaulay and Company Advocates, and states that the applicants ought to have conducted due diligence before making such falsified allegations. On the claim of blocking the instant application and board application, she states the allegations are without any basis. That it is the courts that make orders and not advocates for the purported mob. Lastly, she states that there is no compelling reason to have that has been stated in support of the current application, and therefore urge this court to dismiss it. Margaret Mwihaki Joroge, the widow of the deceased, also filed an affidavit dated 7th April 2025 in opposition to the removal of the advocate herein. She states in support of the application that the applicants herein have raised unsubstantiated allegations in a bid to have the advocate who has been representing her late husband in other cases barred from motion brief for them in this case. She deposits that the family has confidence in the respondent's legal expertise, and they have a right to choose the advocate, and therefore the prayer seeking to bar the advocate from acting for them is a violation of their right to representation. She maintains that if the respondent is barred, they are apprehensive they will not get justice. She terms the arguments advanced by the respondent advanced that the respondent had an affair with her husband as untrue, malicious, and made in bad faith. She therefore prays that the application be dismissed and they be allowed to have the advocate watch brief for the family in this matter. Analysis and determination. From the material before this court, what comes up is the respondent's alleged display of conflict of interest in this case, or having allegedly received information from the accused persons, then turning on to represent, only to turn to represent the family of the deceased. There is the Law Society Code of Conduct of Professional Practice and Ethical Conduct that was published on 26th of May 2017. And this has this to say at paragraph 93 in regard of conflict of interest. A conflicting interest is an interest which gives rise to substantial risk that the advocate's representation of the client will be materially and adversely affected by the advocate's own interest or by the advocate's duties to another client, former client, or a third person. And paragraph 96 thereof lists the instances where conflict of interest can be inferred, and as follows: where the interests of one client are directly adverse to those of another client being represented by the advocate or the firm. For instance, in situations where the representation involves the assertion of a claim by one client against another. B, where the nature of or scope of representation of one client will be materially limited by the advocate's responsibilities to another client, a former client, a third person, or by the personal interest of the advocate. And C, where in the course of representing a client, there is a risk of using, wittingly or unwittingly, information obtained from the current or former client to the disadvantage of that other client or former client. So conflict of interest is invariably linked to the duty of confidentiality against disclosing information received from the client in line of duty. This is expressly provided for under Section 134 of the Evidence Act, which I need not reproduce. But it says, let me just go ahead and read it. No advocate shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his employment as such advocate, by all on behalf of his client, all to state the contents, all condition of any document with which he has become acquainted in the course and for purpose of his professional employment, all to disclose any advice given by him to his client in the course and for purpose of such employment, provided that nothing in this section shall protect from disclosure any communication made in furtherance of any illegal purpose, fact observed by an advocate in the course of his employment as such, showing that any crime or fraud has been committed since the commencement of his employment. And number 2, the protection given by subsection 1 of this section shall continue after employment of the advocate has ceased. From the law quoted above, it is discernible that before a party can accuse an advocate of conflict of interest, they must first demonstrate that there was previously a creation of advocate-client relationship between them, and the advocate they are seeking to bar from acting for the adverse party. For such an advocate to owe them fiduciary duty, and for them to be protected from conflict of interest, and their information termed confidential. The issue then is whether there was an advocate-client relationship between her and the accused persons which would bar her from watching brief for the deceased family. In the present case, it is noted that save for the allegation that the respondent had lengthy talks with the second accused and tried convincing the accused in March to plead guilty, there is no evidence to suggest that there was a creation of advocate-client relationship between the respondent and the applicants. Further, there is nothing placed on record to show that any information or documents was supplied to the respondent that could be used against the applicants, thus prejudicing their defense. In essence, there is nothing on record to support allegations of conflict of interest, whether real or perceived. On issue of disqualification of an advocate, Okubaso J.A. had this to say in this case, William Audi Odede and another versus John Ye and another, Court of Appeal, Civil Application Number Nairobi 360 of 2004. I must state on the onset that it is not the business of the courts to tell litigants which advocates should and should not act in a particular matter. Indeed, each party to litigation has a right to choose his or her advocate, and unless it is shown to the court, to a court of law, that the interest of justice would not be served if a particular advocate were allowed to act in the matter, the parties must be allowed to choose their own counsel. The issues raised regarding the respondent's intimate relationship with the deceased herein seem to be too personal and with no proof, and therefore an unwarranted attack on her. Further, there is no evidence was stated to show that the respondent is not registered to practice. It does not suffice for the applicants to throw wild allegations against the respondent. If indeed she is not qualified, that is an issue within the mandate of the Law Society of Kenya. And indeed, the applicant stated that the issue is under investigations by LSK. There is, however, no evidence of the ongoing investigations and the status thereof. There is also no evidence stated on any report made by the applicants and their advocates to the police or any investigating arm of the government regarding the issues raised by the respondent against the respondent. There is no doubt that the applicants have a right to a fair trial under Article 50 of the Constitution, and indeed that was emphasized by the Court of Appeal in Davis Bank case, where they held the starting point is, of course, to reiterate that most valued constitutional right to a litigant, the right to a legal representative, or advocate of his choice. In some cases, however, particularly in civil, the right may be put to a serious test if there is a conflict of interest which may endanger the equally hallowed principle of confidentiality in advocate-client fiduciary relationships, or where the advocate would double up as a witness. On the other hand, there is the role of the advocate watching brief for the victim that was stated by the the Supreme Court in the Waswa case. And at paragraph 77, this is what the court said: conscious that this is a novel area of law for our criminal justice system, and recognizing our mandate under Section 3 of the Supreme Court Act as the court of final judicial authority, we are of the view that the following guiding principles will assist the trial court when it is considering an application by a victim or his legal representative to participate in a trial and the manner and extent of that participation. A, the applicant must be a direct victim of such victims' legal representative in the case being tried by the court. The court should examine each case according to its special nature to determine if participation is appropriate at the stage of participation is applied for. C, the trial judge must be satisfied that the granting the victim participatory rights shall not occasion an undue delay in the proceedings. Number D, the victim's representation should be strictly limited to, in quotes, the views and concerns of the victim in the matter granted participation. CE, victim participation must not be prejudicial to or inconsistent with the rights of the accused. The trial judge may allow the victim or his legal representative to pose questions to a witness or expert who is giving evidence before the court that have not been posed by the prosecutor. G, the judge has control over the right to ask questions and should ensure that neither the victim nor the accused are not subjected to unsuitable treatment or question that are irrelevant to the trial. H, the trial court should ensure that the victim or the victim's legal representative understands that prosecutorial duties remain solely with the DPP. I, while the victim's views and concerns may be persuasive and no doubt in the public interest that they are acknowledged, those views and concerns are not to be equated with the public interest. The court may hold proceedings in camera where necessary to protect the privacy of the victim, while while the court has a duty to consider the victim's views and concerns, the court has no obligation to follow the victim's preference of punishment. It is therefore evident that the right to representation is both on the accused persons and the victims. Their choice cannot be denied without justification. Some of the reasons warranting interference with the right of representation by an advocate of choice are conflict of interest and in effect the breach of that of the confidentiality. However, there is no evidence that the respondent is a witness in this case, and further, if the applicants ever contacted the respondent Yes, let me repeat. However, there is no evidence that the respondent is a witness in this case, and further, if the applicants ever had a contact with the respondent as alleged, and which has not been proved, then anything they shared with her does not amount to a confession, and it cannot be admissible against them. The applicants have failed to demonstrate how their rights will be prejudiced by the victim's choice of the respondent to represent them in this matter. They have failed also to show that their right to a fair trial has been or will be violated or threatened in any way by the respondent's participation in this matter. In the circumstances, there is reason to interfere with the deceased family's choice on the respondent to watch brief in this case. Likewise, The applicants herein are duly represented by their respective advocates of choice. The respondent should not have any reason to contact or visit them in prison. So in the upshot, the application dated 1st of April 2025 partially succeeds in that this court makes the following orders. Counsel watching brief for the family, Ms. Wamaitha, Ms. Muthama Losarida Wamaitha of P105/17-466/20, commonly practicing in the name of Ms. Wamaitha and or her agents be restrained from visiting the accused persons herein where they are currently held at Nakuru GK prison. All other prayers are dismissed. That is the ruling.
Much obliged, my lady.
You'll get, I should be able to proofread any typo. I actually didn't see much. So we'll upload it for you to access. Now we go to other issues. There was the issue that was remaining, and that was issue of board.
My lady, with your kind permission,
My lady, kindly readmit Miss Award, her call dropped.
Mr. Wall?
Yes, my lady, my apologies. The call dropped.
Welcome back. But I'm not going to repeat. Let me assure you. I have.
Just give me an upshot, my lady.
Sorry?
If you're kind enough to give me an upshot, I'll be okay.
I be kind enough to do what?
To tell me the upshot of the ruling.
So everybody will come in later, will ask me to go back, and I do it. Okay. I will.
This is my lady.
Conclusion. Where I say the upshot.
Yes.
Okay, for your sake. In the upshot, the application dated 1st of April 2025 partially succeeds in that this court makes the following orders. The counsel watching brief, that is Muthama Losarida Wamaitha, and of all her agents be restrained from, be and are hereby restrained from visiting the accused persons herein where they are held at Nakuru GK prison. I've tried to paraphrase it for you. I had read it. Now let's go to the issue. There was the issue of board that was pending. Kindly you people address me on the same. All right. Advocates for the accused persons. Or you are not ready, I give you another day to when you can decide when to proceed with the issue of board.
Lady, on my part, I'm ready. Mùrdered.
Is there anybody who is not there and who may be prejudiced on that? Can I give you a date for that application?
Your Ladyship, that's our take. I'm given a date for 1 year.
Yes, because it was actually coming for ruling, not ruling and board hearing. Isn't that in order? So that whoever is absent will not feel prejudiced.
It's okay, my lady.
Good.
Your Ladyship, will you be kind enough to supply us with a copy of the ruling? To be given the copy of the ruling?
I'm tempted to ignore you because I said that I'm going to applaud it. And that is Mr. Gatti Oguto. Guto.
Then, Mr. Gupta,
Mr. Guto, you know that I upload mine within 24 hours. It is a typed ruling, and I type it. So, Ms. Okok.
Thank you for the ruling, Your Lady.
Ms. Okok, we can have a date for
1 year.
Are we all in agreement that we have a date for board hearing? And if it is to be done, just hold, if it is to be done, do we have affidavits? By all? There was.
Yes, my lady. On my part, I had filed an affidavit on the same. Also believe Mr. Gatti did the same.
Ms. Owol and Gatti.
My lady, I also filed my affidavit with respect to the third accused, and Ms. Annie Bugi also filed for the second.
I keep reminding you that for purposes of recording and transcription, when you're addressing me, say who. I may not remember.
Sorry, Ms. Miranda for the third accused. Equally holding brief for Ms. Annie Bugi for the second accused. We have both filed affidavits with respect to bond.
Hold there, I confirm. Okay, let me just alert you so that if I don't get yours, you can tell me. I have the affidavit by the prosecution, I think opposing board. It is the sworn by Inspector Patrick Washira of DCI. There is for the accused response to affidavit in opposition to board, and that is sworn by Beryl Awol. We have Peter Okech, alias DJ, who filed a replying affidavit, and this is in who is Wangoi Karimu and Company Advocates. This person calling himself Peter Okech, alias DJ, this is an accused person. DJ. Okay, proceed. Second accused. Affidavit in support of application by Joseph Kihara Kariuki. The third applicant. Respondents replying we are done. Who didn't hear? about his reply affidavit. Any other business? So there is no other business or